Joining us now on the set is Christopher Farrell. He is with Judicial Watch. He is their investigations and research director. Good morning.
Good morning.
To the point that the last guest was making, that you should look at this release of the memo in two separate phases, not necessarily what about the FISA process and not necessarily the larger aspect of the Mueller investigation. Is that something that you would agree with or disagree with?
I would. There's a lot of moving pieces here. So if you want to back up even to a higher level, you can say, well, what has been the success rate of this entire affair as a Russian active measures campaign? If the goal was to disrupt and confuse and generate all sorts of consternation and finger pointing, well, then the Russians have been quite successful, haven't they? And that's really kind of the larger question, I think. We have an internal domestic question politically, because obviously this is an enormously divisive and hot issue with a lot of finger pointing and claims and counterclaims. That will all play itself out, and I think we'll get to the truth or to the ground of it at some point. But the larger question is, for the last 100 years, whether it's the Soviet Union or the Russians in one form politically or another, they've been very aggressive in active measures campaigns, influence operations, information warfare, and we're seeing the outcome, the byproduct of it now.
What do you think about the quality of the Republican memo that was put out last week?
To me, it's pretty factually based. I mean, I've looked at what the claims have been made. We've seen the text messages of people like Mr. Strzok and his girlfriend, Paige. It either happened or it didn't. And that's partially why Judicial Watch is in court now suing to gain access to the actual FISA warrants themselves, because rather than relying on the representations of Mr. Nunes or Mr. Schiff saying, oh no, this is all a lie, let's get it all public. Let's get these FISA warrants and let the public review them themselves, because the way that they're structured, there's an underlying sworn declaration or affidavit from a special agent or an attorney, either an FBI agent or a DOJ attorney, that lays out the case. And then that's an enclosure to the warrant application itself, which is executed by a deputy attorney general or higher, even the attorney general himself, saying, look, Judge, we need access to this because the subject is either an agent of a foreign power or is a terrorist. Both are applicable. And let's see what the case was. Let's see what the statements are. Because in this case, they've relied upon, Deputy Director McCabe has said that they relied upon this Fusion GPS Steele memo or dossier. So we know that that's, or at least he's sworn under oath that that's true. But if there's more, what is it? And when they've renewed these applications for the warrants, they had they, meaning the Department of Justice and the FBI, they had an affirmative obligation to update and inform the court, each judge, the 4 different judges involved, at least that's my understanding. They had an affirmative obligation to correct or perfect the record. So what did they submit? Let's see what it is.
Our guest with us for about 45 minutes. If you want to talk to him and ask him questions about the release of this memo, what it does for the FISA process, the larger aspects of the Mueller investigation, 202-748-8000, one for Republicans, 202-748-8000 for Democrats, 202-748-8002 for independents. Our guest is the Director of Investigations and Research at Judicial Watch. A little bit about the organization for those who don't know.
Sure. We're a government watchdog group. We promote transparency, integrity, and accountability in government, politics, and the law. We do it as an educational foundation. Our goal is to educate the public about the operations of government. We make very aggressive use of the Freedom of Information Act, or FOIA. We're the largest FOIA litigator in the country. The next 2 or 3 sort of public interest groups combined don't equal what we do with respect to both filing FOIA requests, but then also litigating them. And so our goal is really government accountability. That's what we're looking for. Philosophically, we are conservative, but we're nonpartisan in the sense that we never endorse candidates or parties or legislation. So we come at this from a philosophical point of view, just as sort of one would argue the ACLU comes at it from a more of a left point of view.
So when you hear the president say this memo released last week totally vindicates me when it comes to the larger aspect of the Mueller investigation. Your point would be? My
point would be that I have yet to hear anyone articulate the criminal predicate for the Mueller investigation. What crime was committed? I mean, in our system of justice, we identify the crime, and then we find suspects, and then we narrow it down, and either we bring an indictment or we don't. In this case, it appears that we've identified suspects, and now we're going to investigate until we find the crime. That's kind of upside down. It isn't historically the way that we operate. And so, you know, with respect to the Hillary Clinton email issue, I can tell you 18 U.S.C. Section 793F is mishandling national defense information. I can articulate the crime, I can explain the elements of the crime, and I can show you how Mrs. Clinton violated each and every one of those elements. And I say that because in my past professional life, I was a special agent of Army counterintelligence. So I've investigated these cases, I've brought them, have successfully had people prosecuted. So I know what that is. When I look at Mueller and I hear people say collusion, okay, what you may mean is conspiracy, because collusion itself is not a crime. But what's the underlying criminal predicate? What are you alleging was done unlawfully? I have yet to hear anyone articulate what the what the crime is.
Back to your request for the information, for the underlying information, how do you release that and still maintain concerns or at least the national security control qualities?
Right. So when it comes to anything having to do with classified information, the two things that are of greatest concern for any sort of public release are sources and methods. That's what people hear over and over again. And so when they talk about sources, it's what was the means by which the intelligence was collected. And so whether it's human intelligence, signals intelligence, there's all these various flavors of int or intelligence. What was the technique, and then what was the source? And so in human intelligence, obviously we don't want to burn or put anybody in jeopardy who's reporting to us. We don't want to compromise technical collection capabilities, whether it's signals intelligence or imagery, those sorts of things. But once you've carved that out, once you've taken away the sources and methods, then it's really just sort of a narrative of, well, what was the information gleaned? And in large part, the president and the agencies themselves enjoy broad discretionary power to release stuff. They may wish to redact a name here or there, but an awful lot of this can be released on a discretionary basis.
On the topic of methods, then, our previous guest talked about the Steele dossier and the background and how it was funded and things like that,
right.
And seemed to suggest that even if those things were revealed out in full in the process of the FISA court applying these applications, that there had to be more there in order to base their judgment. Do you buy that argument?
In part. I mean, that argument can be made in a valid way, but we already have the sworn declaration or statements of Mr. McCabe saying that the FISA warrant was entirely dependent upon the Steele dossier. There's one point I would disagree with the prior guest on, and that is he makes a distinction between criminal investigations and counterintelligence investigations. That's a distinction without a difference. Counterintelligence investigations are national security crimes. They are criminal investigations. So there's times when people throw that up as being some sort of it isn't really what it appears to be. It is. National security crimes, which are counterintelligence investigations, are crimes. And so I would disagree with the prior guest on that, because there's a lot of people sitting in jail on counterintelligence investigations.
We have calls lined up for you.
Sure.
First call for Christopher Farrell is Philip in Michigan. Democrats line, you're on with our guest. Go ahead, Philip, you're on.
Yeah, my answer to the previous caller is the opposite idea, is that the president should come on and just go, I'm going to take the Fifth Amendment. I have a right to take the Fifth Amendment, and he should announce that he's going to do so. That would blow all the air out of the whole issue. And if Clinton had taken the Fifth, it would have just destroyed the whole thing. They'd have never been able to go to impeach Clinton, and that's my comment. Thank you, C-SPAN.
Can the president just, when it comes to the information that we talked about, can the president just release it at will?
Yes, he has absolute discretionary authority with respect to classified information. The the thing that I always hearken back to is President Carter made the intelligence community crazy when he got up at a campaign event in Miami and started discussing national intelligence collection platforms from satellites. And that was sort of a precedent-breaking or setting event. And his authority was, well, I'm the president and I can do it. And that is the case.
Nashville, Tennessee, Clarence, Republican line. Hi, you're on.
Good morning, gentlemen. My point on this is the FISA warrant gave the FBI permission to wiretap, which they had not had permission to do in all the other time they had spent on Mr. Page. But this wiretap gave them entrance to the Trump campaign to then chain react and pick up conversations of anybody and everybody that Page was talking to, and that's what their interest was. Not in what Russians were being discussed, but what different members of the campaign had to say. And so they were looking for a whole lot more than just Page. And I think it was a real travesty of what happened. And they keep talking about 4 different judges. I'm not so sure it was 4 different judges, and I don't think this guest or the previous guest, who mentioned it about 4 times, know whether it was 4 different judges.
Okay.
The same judge 2 times, 3 times.
We'll let our guest respond. Thank you.
My reference to 4 different judges is just based upon public reporting. I have no special knowledge. But what I do know is that we've sued to get those records. And so we'll find out if there are 4 different judges, 1 judge, however many that are out there. I think the Carter Page angle of the whole foundation, I guess, for the warrant is interesting. Based on my research, Mr. Page had no official position with the campaign. He's identified as an advisor, but from what I understand, he held no office. He didn't have a desk, a phone number. He was a sort of a volunteer advisor. So I'm always curious about the language that's used and how people are characterized, because I don't know how close he really ever was to the inner circle of the Trump campaign. I think he sort of self-identified as, well, I'm an advisor, and I think that his name had been used, but he didn't, from my understanding, he held no actual position or title or, sort of a business card and desk and office kind of that's not my understanding, which I think that's even kind of interesting.
What did you make from the document that was released, the last paragraph talking specifically about George Papadopoulos as the trigger to this whole thing?
It's a hearsay kind of thing, right? So here's this guy who heard something, who told the guy in a bar. It's pretty thin stuff. Again, I'm always concerned, right? I have been concerned since 2013 with respect to how warrants were obtained for these national security questions. And I go back to the former Fox journalist James Rosen and the Justice Department's efforts to gain access to his phone records and to even, I think, his parents' phone records. Because a declaration was made by a FBI special agent and then affirmed or confirmed by the Attorney General. And the claim was that James Rosen was an agent of a foreign power and a flight risk. And I don't think he was either. He was a Fox News reporter who was working on a story at the State Department about Korea. Now, they may not like that the journalist is asking questions about things they'd rather not discuss, but that's a separate issue. That isn't saying that he's an espionage agent and a flight risk. But they submitted sworn declarations to a court in order to gain access to his records. And the Holder Justice Department did the very same thing with the Associated Press, also reporting around May 2013. They were clearly lying. They were making false and misleading statements in order to obtain warrants. There's a track record here. This is not anything new, and that's really the disturbing part. We now have evidence over a couple of administrations that the Justice Department and the FBI will lie under oath to judges to get warrants. that's the lesson here. That's the warning that these powers are being abused at an outrageous level with little or no accountability.
We have a viewer on Twitter who asked this question. I believe he's referencing the Steele dossier in effort to gain the warrant, saying, are people laboring under the misconception that a flawed source can never provide the basis of a warrant application and issuance? They don't. Outright criminals fill the ranks of confidential informants on whose info many warrants are issued.
Yeah, I mean, even a stopped clock is right twice a day, right? So a source providing information can be deeply flawed and troubled in all sorts of ways. Certainly in criminal cases, if law enforcement only dealt with Boy Scouts, they would never develop any information, right? So sometimes there's bad guys out there that you would talk to or recruit or in some way develop information from that would result in a warrant being sworn out or advanced. So, but there's a balancing test here, and there's a credibility question. And if you do have information coming from a unsavory source, that's why you need to check and double check and develop other sources. Sometimes you don't have another source. Sometimes the only information you have is from somebody who is in some way, let's say, imperfect or defective in some way. That doesn't necessarily end the investigation. It just makes you work harder.
And so when it applies to the Steele dossier itself, if the full scope of the dossier and the background and everything that behind it were revealed, do you think then that would, and a judge would have allowed it, do you think that would have been proper, or it would have been bolstered by other things that the judge may have access to?
See, the problem in the Steele dossier is that it was very artfully and craftfully sort of planted and then cycled and then recycled. So you have this Isikoff reporting
From Yahoo News.
But then when you go back and you say, okay, well, who else was working on this? Well, Fusion GPS. All right, well, who were they paid by? And who was working at Fusion GPS? And then you get into the whole Nellie or the Fusion GPS analyst or researcher, and then her tie back to her husband, Bruce Orr, who has this very senior position in the Justice Department, who seems to be in this sort of McCabe-Strzok circle. This is murky stuff. And if you look at it, it appears that this is a very sophisticated influence operation. It's an attempt to generate a narrative that doesn't seem legitimate.
You're after the underlying documents. The Democrats say, release our memo. It'll give context to everything the Republicans put out.
I'm all for it. I want to see everything released. I want all the cards on the table. I'm tired of the finger pointing and the hysteria. I want this whole thing blown out into the open. If there's something there, great. Indict someone. Get a grand jury. Let's go to trial. I'm tired of sort of rumor and innuendo and I look at Mr. Mueller's investigation so far. I mean, he may have had a couple of indictments, and General Flynn may have pled out to 18 U.S.C. 1001. This is pretty thin stuff. And like I said, if you take a great big step back and look at it, I think that Putin and the Russians are laughing because they have so manipulated the American political system and sown so much dissent. And really, that's the larger question. I'm more concerned about the United States than, the efforts of various political operatives trying to manipulate a system.
Chris Farrell of Judicial Watch joining us. Let's hear from Vernon in Allen, Texas, Independent Line. Go ahead.
Yes, good morning, Pedro. Christopher Farrell, thank you very much for Judicial Watch.
Thanks.
I'd like to say two things. First of all, we begin with false narratives all the time. In the case of the memo, when it was put out, it was initially stated this has nothing to do with anything but the fact that the committee has oversight responsibility for the FBI and the Department of Justice, and what they are doing, and in their disclosure, is strictly to do with the presentation of facts so that we can determine whether or not people were lying when they submitted information to the FISA court. Now, let's talk about that as far as the narrative goes. The other narrative that is a false one And it has to do, again, thank you, Mr. Farrell. You laid it out pretty well here as I've been on the phone waiting. And it all goes back to the fact that the Russians getting involved in our electoral system is nothing new. Nothing new at all.
Okay, caller, thanks.
Yeah, I mean, the caller makes a great point. Whether it's the Soviet Union or the modern-day Russia, they have their interests and their objectives, and they're going to do what they think are in their best first interests. So we shouldn't be surprised that they attempt to manipulate in any number of ways the system. I mean, you go back to 1933 and FDR granting diplomatic status to the Soviet Union. The Russians literally laughed at us. I mean, there's sufficient documentation about that entire November 33 event. The Russians are quite canny and quite sophisticated in their efforts to advance their agenda. And if we're busy, kind of chasing our tails and attacking each other, they're quite pleased with that.
From Michigan, Dave, Democrats line. Hello.
Hello, good morning. Listen, this is actually kind of stunning what your guest is saying here. He's obviously, this is not a nonpartisan attitude. You're saying that there's not evidence for collusion. Well, let's wait until the investigation's done. But do you think the Russian intrusion was a hoax?
No, I think the Russians certainly had all sorts of interests in trying to affect the outcome of our elections. And like I said, they've been doing it for 100 years. There's absolutely nothing new about it. But again, to the caller's remark about collusion, I need someone to tell me, identify for me the crime. What is the criminal predicate that's occurred? No one can articulate it. No one. Certainly Mr. Mueller hasn't. So tell me what occurred and what was unlawful, and identify for me the criminal act and then the suspects that you think have done something.
Give me a for instance. When does it rise to conspiracy?
All right, well, you need to have, first of all, I mean, here's a great example. I'll give you one. General Flynn, for whatever reason, pled out to an information, it's sort of a complaint, but nonetheless, an information is what they call it, under Title 18 of the U.S. Code, Section 1001, which is false official statement. It is unlawful to lie to a federal agent who's interviewing you. Now, normally when that happens, and this is based on my personal experience, but also other colleagues of mine who are other federal agents, normally when that happens, in addition to the 1001 claim or false official statement, there's a claim for 371, which is conspiracy, and then some other criminal, whether it's fraud or some other criminal act. The reason being is I catch you in a falsehood. And I say, well, who else are you working with? And you say, well, I was working with Bill, Frank, and Tony. Okay, now I've got the conspiracy. Well, what were you and Bill and Frank and Tony doing? And then they say, well, we were defrauding the company. We stole money or products, or we phonied up the books. There's the crime, right? But when you bring a false official statement charge against somebody, but no conspiracy count, and no underlying crime, it's really pretty thin stuff in the world of criminal prosecutions. Prosecutors want indictments and convictions. They're looking for scalps, right? That's the way they operate. And when you go with a false official statement charge, it's the lowest of the rungs. Here's the point I'm trying to make. If I'm a federal agent and I'm interviewing you, and I do so for 2 hours, I'll find something that you said that is inconsistent. One time you said of, another time you said from, and I will drill down on that and say that you made misleading statements to me. You're attempting to. And so that is the situation here with General Flynn. He, I think, very wrong-headedly, obviously he made some error and he's pled out to it and he's responsible for his actions. I'm not trying to forgive or make an excuse for that. Mm-hmm. But all I'm saying is, for the average American citizen out there, if a federal agent's interviewing you for a couple of hours, if they want to, they've got a false official statement claim.
Richmond, Virginia, Republican line. Mike is next for our guest, Chris Farrell. Hi.
Hi, guys.
I appreciate all the fine legal points that you're discussing here, but for me, this all revolves around motivation. And when you look back at what happened, not just with regards to the Mueller investigation or this FISA court situation, but rather the entirety of what happened in the months leading up to the election. And we saw plainly that there's something very wrong going on in the Justice Department, in the FBI, because on the 5th of July of 2016, Mr. Comey stood up and told all of us all of the crimes that Hillary Clinton had committed, and then told us that there would be no indictments for all these crimes. Then the following day, when Trey Gowdy was questioning him, Trey Gowdy was saying, did Mrs. Clinton commit this crime that violated this statute? And Comey said yes. And did she commit that crime that violated that statute? And Comey said yes. And still, there was not going to be any indictment. We knew at that point something had happened at the FBI that we really, as a nation, we don't want to face.
Okay,
the
caller,
FBI is.
Thanks.
But I have one more thing.
No, caller, leave it there. We'll leave it there, Mr. Farrell.
No, it's an excellent point by the caller. Mr. Comey's press briefing on the 5th of July, he essentially, for the first 13 and a half minutes of the 15-minute briefing, he laid out all of the elements of the crime of 18 U.S.C. Section 793F, mishandling national defense information. So he identified each of the elements of the crime. He gave examples of how Mrs. Clinton and her circle of associates violated that quite specifically. And then towards the end, he invented out of thin air a new element, which was intent. That particular crime that I just highlighted, I don't want to keep repeating it, but it's important. There's no requirement for intent in that particular mishandling of national defense information. It's kind of unique, not entirely unique, but it's unusual. There's no requirement for intent. He manufactured a new standard or a new threshold for satisfying the element of the crime, and then went way beyond his scope as an investigator and made the decision of the Attorney General and said, no, we're not going to prosecute it. It's aberrant. There's nothing else like it in our criminal justice history. Nowhere.
Our guest serves with Judicial Watch. He's their investigations and research director. In his previous career, he was a military intelligence officer specializing in counterintelligence and human intelligence. Huntington, West Virginia, independent line. Pat is next. Pat, good morning. Go ahead.
Good morning, Pedro. I don't want to go into the idea about whether this fellow is nonpartisan or anything like that. What I'd like to ask is this. If I am a public official and I run a business and I steer a contract towards that business by using my office, that is clearly against the law. And what I want to ask him is this. Every weekend, Trump goes down to Mar-a-Lago, stays at his resort. I'm sure that he houses a lot of his security detail and some of his entourage there that travels with him. He collects money off of that, puts money in his pocket from that, and isn't that a clear violation of the emollient clause that we have written into our laws? And how come nobody is drilling down on this and getting tied up in all this stuff that nobody can really come to a serious conclusion about?
Got it, Pat. Thank you.
A few things. Judicial Watch has requested and continues to request all travel-related costs and documents with respect to the president's travel, whether it's down to Florida or anywhere else. And so we're trying to provide accountability to the American public on travel costs and frequency and all the related things like that. For example, when the president moves, obviously there's a big sort of tail that goes with that. And so there's Secret Service costs and any number of things. And so we request those documents. Unfortunately, we often have to sue to compel the government to produce those records, but that's fine. We're happy to do it. And so all those costs we're trying to account for. I don't think that the president travels every weekend to Florida. That the caller kind of predicated that as every weekend he goes there. It's his home.
Is it a violation of Emollients Act?
I have a hard time getting there. I don't believe that it's so. That's his property and his home, and he's allowed to go there. You can make here's a parallel. Former Vice President Biden had a home in Delaware, and I guess there was a guest house on the property that the Secret Service used to secure the facility. And I think that he was actually charging the Secret Service for the use of the guest house. I mean, you could say, well, aha, he's making money from it. That's not what the Emoluments Clause talks about. It gets sticky when you have people with properties and there's a requirement to secure them and they have to have their staff. The president can't not have the White House Communications Agency going with them. The requirements of the office can't be dispensed with simply because the guy has a large property in Florida.
A legal question from Twitter, and you can answer it as you will. Does Chris Farrell feel that the judge from the FISA court has grounds for pressing charges of contempt on the FBI?
If he's been misled, if they made false and misleading statements to him, if they deliberately manipulated the record, as they have, and we discussed the two cases from 2013 where they clearly did, then yeah, don't lie to a court. It's a bad idea.
Absalom is in Washington, D.C. Democrats line for our guest, Chris Farrell. Go ahead.
Yeah, I want to know if Mr. Farrell is an attorney first.
I am not an attorney.
Okay, that's good. Then what happens is your organization has a conservative agenda that it wants to promote, and that's to shift the focus from the Trump situation to Clinton. My brother, who is a retired colonel, had me look up Executive Order 13526 when the issue first came out about Clinton. And Part 1, Section 1.3 provides that Clinton is designated as an original originator. And as such, she had the authority to classify, declassify information and what have you. But here's my concern. The president just recently declassified information. Why isn't Judicial Watch asking Trump to do the same thing with the FISA warrants? He can declassify all of the FISA warrants related to this case, and you don't have to go through the judiciary in order to accomplish that goal.
Okay, thanks, caller.
Trump.
It's not entirely that simple because the warrants themselves are judicial, or they generate themselves from the Department of Justice, and then they go before this court. We did ask, and we unfortunately lost in court last week. We asked Judge Boasberg to release all the Comey memos. We were joined in that by other news agencies, CNN and many others, because we said, look, let's get to the bottom of it, release it all. And Judge Boasberg, who also happens to sit on the FISA court, interestingly, he declined to release all of the Comey memos. He has his reasoning and he's issued his order. We'll continue to pursue them legally. And then these FISA warrants, again, there is a legal predicate or structure for how that they're maintained and processed. We've asked for them. We've sued now to gain access to them. We're using every legal means available to obtain this information and to make it public, because from our point of view, the more that's public concerning this whole issue, the better.
Previous guests talked about this issue being a call for reforms of FISA, or at least the process. Would you agree with that? And if so, what could be changed to improve the process?
Yeah, I heard a short piece of that. There needs to be far greater skepticism with respect to sort of the underlying documentation and frankly, the willingness of both the FBI and the DOJ to lie. They've made false and misleading statements to courts under oath. It is horrendous. There needs to be prosecutions of that. The fact that these government officials can do these sorts of things and then just kind of shrug and go off and do whatever they want is outrageous. So I would look for indictments of those persons. There's got to be consequences. We can't go through this entire turmoil and then have everybody just kind of walk away and say, oh, well, gee, that was tough. There have got to be consequences, legal consequences. I don't care where it goes. If there's people out there in DOJ and FBI or any other agency, I mean, for example, we have this whole thing that is sort of a corollary to what we're talking about today, and that is the whole unmasking controversy. If, in fact, it's true that the former U.S. ambassador to the UN made 200 and some odd unmasking requests, that's an outrageous abuse of the system. Samantha Power is the person I'm discussing. If she or her assistants in some way abuse that system, you don't hear a word about unmasking anymore. What happened with that? Just before the New Year, before Christmas, there was a lot of huff and puff in the news about a confidential informant who'd been working on the Uranium One case, and he was supposed to come forward and make public testimony. I haven't heard a peep. So there's all these unresolved kind of like related corollary scandals tied to this, where there's a burst of information or a sudden amount of interest, and then everyone gets amnesia. I don't have amnesia on this. I'm not going to forget it, and we're going to continue to pursue it. There's got to be accountability. I don't care where it goes or who gets, muddied in this thing. We just need straight answers, and that's the frustrating thing with the FISA court, and that's why we have to get the records themselves. Maybe there needs to be a public advocate, like your prior guest had said, where you just bring in some informed yet disinterested third party who knows the law, who knows the system, and they just get to ask inconvenient questions. Ask the tough, awkward question. Well, how do you know that? Or why is this in the application but this isn't? Just to be a devil's advocate, I think that there may be a place for that.
Republican line, Mark in Bensalem, Pennsylvania.
Good morning. Good morning. I'm really interested why that we're getting into the fine details and minutiae of this FISA warrant. The big picture is all before us now. We know there was collusion. We know the Mueller investigation is not doing what they're supposed to because of the fact that we had all the heads of the FBI and all these other agencies lie before Congress saying that the Donald Trump staff was not under investigation. And that was a blatant lie, and it was proved by this document that the Republicans have just put out. Secondarily, we know where all the problems came from. It was the Steele dossier and Fusion GPS. All the problems initiated from there. And yet Mueller's not doing anything to investigate that. It shows clearly that he's not interested in getting to where the collusion was or conspiracy or Russian involvement, because it all stems from that. In fact, even Don Jr.'s thing stemmed from Fusion GPS. They made the lawyer and they made her meet with them before and after. It was all set up by them, and it was all paid for by Hillary Clinton. So I don't know why we're wasting time with what's the underlying documents in the FISA warrant. We know it was used. That's all we have to know.
Okay. That's all we have to know, he says.
Well, I agree in general with what he's saying, but I think that the documentation is absolutely critical. And the reason why it is because this is a shorthand thing that I tell my students. People lie, documents don't. So I want to see the underlying foundation documentary evidence. That's critical from my point of view. But I think, interestingly, he kind of made a passing reference to this with respect to the president's son. But the Russian attorney who met with the president's son, I guess up at Trump Tower, what doesn't get enough attention, but I think is very interesting, is a very curious little phenomenon, is that the Fusion GPS people met with her beforehand and then dispatched her into the meeting. And then she had this meeting with the Trump people. And then she came out of the meeting and was reportedly met again by Fusion GPS people. In the intelligence world, that's called dispatch, action, and then recovery or debriefing, right? That's it leads one to question exactly what the relationships were and who was reporting to who and what sort of information was trying to be developed. It's very curious. So that, look, we have these Strzok and Page text messages. We have McCabe's involvement with via his spouse with McAuliffe. This is all very murky stuff, and for anybody to just shrug and say, oh, well, it's all coincidental, and then talking about meeting with Andy and having an insurance policy, this kind of stuff, this is incendiary material.
So when you hear the term deep state applied to this, is that something you agree with?
In this case, yes, because there's sort of professional political class that operates outside of what the election results may or may not be. There's also literally hundreds of Obama administration Schedule C political appointees who are still operating in the government. Now, you could say, well, that's because President Trump hasn't appointed enough people or the right people or whatever. True. But people don't realize that, the government, the sort of the professional political class in Washington, D.C., they have their own sort of institutional authority and power and leverage. And no matter who comes in or out of office, they're there for decades. And that is what every administration faces, whether the staff sort of willingly goes along or just makes mistakes and doesn't entirely cooperate with the new administration. It's a big challenge.
Let's go to Dana in California, Independent Line.
Good morning, Mr. Farrell. 3 quick questions. The first is, what are the legal ramifications of the Nunes memo? Is it just one intelligence committee after another who's going to keep looking into more and more allegations of improperly obtained information? The second question I have is, does this not cast doubt on the entire institution of the FBI as a whole and their methods? And isn't that a bit of a stretch to make? And the third question is, don't you think that accountability works both ways for politicians and the FBI, because both groups are people who uphold the law anyway? Thank you very much for taking my call.
Sure. So the implications of the Nunes memo are that there was an abuse of the system and process. It appears to have been deliberate, thoughtful, a conspiracy, literally. How that plays out, I think, is a question that the Attorney General has now referred to the DOJ OIG to examine the conduct of the persons involved. So that is my interpretation of the outcome of the Nunes menu. With respect to institutional problems at the Department of Justice and FBI, yeah, there really needs to be a house cleaning. Here's the kind of, I don't know whether it's sad or shocking or both. All this sort of abuse or this concerted effort, let's just call it, at senior levels within DOJ and FBI is sort of a byproduct of the Washington hothouse environment at headquarters. But it's also a case where in individual field offices around the country, there's been extraordinary abuse of normally warrant-approved activities, such as electronic surveillance, concealed monitoring, mail cover, those sorts of things. I can point a finger directly at El Paso, Texas. There's an outrageous amount of, or had been past tense, up until at least my memory of this ends at about 4 years ago. Outrageous abuse of U.S. persons' constitutional rights. We've investigated it. We've brought it to Senator Grassley. It's been the subject of a Department of Justice Inspector General investigation. The FBI office in El Paso is a rat's nest of corruption. It's not alone. There are people, when they're given extraordinary power and extraordinary means to collect information, they'll use it. It's very rare that the government does not fully use all the powers vested to it. And that's subject to abuse. The last point on accountability, I couldn't agree more. The politicians need to be accountable, but just so also the civil servants who are, there are trusted servants, right? We're sovereign, and we give them this authority and ability to serve us. And when they start using it for their own purposes, that's a very grave abuse.
Democrats say the release of the memo itself on the Republican side damaged national security on a lot of fronts. What do you think about that argument?
It's a little schizophrenic. At first, they were howling that it was going to be the end of the world and all sorts of national security issues were going to be disclosed and it would be damaging. And then once it was released, I'll quote Mr. Comey, so what? Is that all you got? Or he made some sort of flippant remark. So before the release of the memo, there was hysteria and hand-wringing and, oh my goodness, it's the end of the world. Then the memo comes out and everyone knocks the memo and says it's no big deal, who cares, it's all phony anyway. You can't have it both ways. Either it was going to be the end of the world or so what? I mean, and so it's just, it's posturing, it's kabuki theater. It's all sorts of maneuvering and ritualized behavior just for political advantage. But the underlying question about did something occur or not, that is what has to be answered.
Let's go to our last call, and that's Jim in West Virginia, Democrats line.
Yes, I appreciate Mr. Farrell being on there, but I mean, from things he said, he strikes me as pretty disingenuous. He strikes me as a typical Republican, taking a typical Republican stance that anything that conservatives do, it's okay, it's righteous. And anything the Democrats do, oh my, there's something underhanded. I mean, he was speaking of Hillary Clinton. Let's look back at 4 years of Republicans, roasting her slowly on a barbecue spit, trying to find something wrong. Well, certainly they found out through the Benghazi proceedings, after 4 years, oh, wow, she used a private server. But I would ask, as an earlier caller did, she was a Secretary of State. Did she do anything wrong through things that were leaked through WikiLeaks, hacking of the DNC, hacking of emails, and having to be at 8 different hearings and testimony? What did she do wrong?
Okay, well, let him answer.
So to start off, I am not a Republican. I'm not a member of any political party. The notion that I'm being disingenuous, I find to be offensive. I'm telling you exactly what I think and what I feel, and I have lots of documentation to back it up. With respect to Mrs. Clinton, the Inspector General of the intelligence community conducted their own investigation and identified 22 top secret, sensitive, compartmented information emails that transited her server. She established the server, in my opinion, to avoid the Freedom of Information Act, and she is in violation of 18 U.S.C. Section 793F, which is the mishandling of national defense information. There are people sitting in prison for doing a tiny fraction of what she and her associates did. And so I'll leave it there.
Chris Farrell of Judicial Watch, the Director of Investigations of Research, judicialwatch.org, the website. Thanks for your time.
Thank you, Pedro.
Open phones until the end of the program at 10 o'clock, 202-748-8001 for Republicans, 202-748-8000 for Democrats, Independents, 202-748-8002. We'll take those when we come back.